I do have skills that make me a nightmare for people like you.
Hey people, right, so part 31 of the $80 ticket saga. This is the Memorandum of Counsel for the Police on application by the defendant for costs. So this was their submissions in regards to costs. This was after it had been dismissed. This was by Kate Blackmore of the Police Prosecution. It reads as follows. May it please the court. Mark Donald Eric Keane, the defendant, appeared for the judge alone trial on the 9th of February 2018 in respect of an infringement offence of exceeding 80 km per hour pursuant to sections 40 and 133 of the Land Transport Act 1998, the LTA, and regulations 3 and 4 of the Land Transport Offences and Penalties Regulations 1999, Offence Regulations, and Land Transport Road User Rules 2004, Road User Rules. The infringement offence is a finable only matter with a maximum fine of $1,000 applicable upon conviction. The infringement fee for the speed alleged by the offence was $80. 2. The matter came before Her Honour, Judge Mathers, pursuant to a notice of a hearing in respect of an infringement offence issued pursuant to sections 21, subsections 6, 7 and 8 of the Summary Proceedings Act 1957, and proceeded as a judge-alone trial following 2 prior appearances at Auckland District Court. The police file records the prior appearances as follows. A. First appearance hearing on the 13th of July whereby deemed a not guilty plea was entered before DCJ Black. B. 2-hour fixture for judge-alone trial on the 7th of November before Her Honour Judge Mathers, resulting in an adjournment for the judge-alone trial set for the 9th of February 2018. 3. Counsel was not present at the fixture on the 7th of November 2017, but understands that the matter was adjourned to a subsequent judge-alone trial date as a result of significant discussions inter alia regarding the defendant's allegations as to the failure by the prosecution to provide full disclosure of various documents, and the appointment of an Amicus curiae to assist the court. 4. At the onset of the judge-alone trial, which proceeded on the 9th of February 2018, the judge-alone trial, the defendant sought by application to record the proceedings. That application, as dismissed by Judge Mathers inter alia, as the matter would be recorded by the court audio recording system and subsequently transcribed, and that the defendant would be provided with a copy of that transcript after the hearing. 5. The judge-alone trial proceeded and the prosecution called one witness, namely a Mr. I'll leave that out. After the close of the prosecution case and after the defendant elected not to give or call evidence, Her Honour Judge Mathers reserved her decision pending receipt of written submissions directed to be filed by the prosecution and the defendant. The defendant remained self-represented at the hearing, although the amicus, Mr. Chambers, was available to assist him and the court. Prior to the filing of the written submissions by the prosecution or defendant, Her Honour Judge Mathers issued a minute dated the 16th of February advising that the recording system was not operating as expected and the parties were directed to appear in person at the Auckland District Court to give submissions in person on how the matter was to proceed. On the 16th of February, counsel advised that the prosecution would seek to withdraw and not proceed with the infringement offence to a rehearing as it would not meet the public interest test under the Crown Prosecution Guidelines. In all the circumstances, and despite the prosecution's view of the strong evidential sufficiency of the prosecution case, the matter was recorded by Her Honour as being dismissed by consent. However, given the claim by the defendant for costs in the documents filed entitled Motions for Costs as a Successful Defendant, dated 9th of February 2018, the matter was further remanded for police to file submissions on the claim for costs which is opposed. This memorandum is filed herewith accordingly. 8. Counsel sincerely apologises to the court and the defendant and Amicus for the 2-day delay from the timetable in filing these submissions. Background. 9. The prosecution case led at the judge-alone trial included inter alia the following. A. On the 22nd of April 2017, the defendant was alleged to have committed an infringement offence by having driven on the Northwestern Motorway, State Highway 16 at Auckland at a speed exceeding a temporary speed limit of 80 km per hour, being an offence detected by approved vehicle surveillance equipment, an infringement notice. B. The evidence for the prosecution given by the witness, who was speed camera operator, included, along with the production of various exhibits in support, as recorded and or recalled by counsel, given that no transcript is available. A. On the 22nd of April, he was deployed in his mobile camera van to the Northwestern Motorway in a temporary speed zone of 80 km per hour in his unmarked police vehicle registration EUR 591. B. That no relevant traffic signs were obscured and that the speed camera in his vehicle, which had a current certificate of accuracy at the time, had been set up and deployed correctly. C. That he held the appropriate certificate of training to operate the speed camera. D. That one of the vehicles which was photographed exceeding the speed limit was the vehicle registration number AAWU69 with a recorded speed of 94 km per hour at 12:15 a.m. on the 22nd of April. E. That following the deployment of the camera, speed infringement information was sent off to the Police Infringement Bureau, who issued infringement fees. F. An infringement notice number 1058327 was issued on the 29th of April 2018 and subsequently served on the defendant, containing the above allegations at 4A. G. Upon receipt of the notice of hearing for the infringement offence, the witness sent various documents to the defendant, including a copy of the photograph capturing the vehicle and speed, a brief of evidence, the certification from New Zealand Transport Authority as to the ownership of the vehicle, AAWU69, certified certificate of accuracy of the speed camera. H. The witness did not at any time receive a notice of statutory declaration from the defendant advising he was not the driver or advising who the driver of the vehicle AAWU69 at the time of the alleged infringement was. I. The vehicle AAWU69 is registered in the name of the defendant. 10. The above facts and prosecution case was for the most part denied by the defendant. The defendant had the opportunity to cross-examine the witness at the judge-alone trial on the factual and legal matters he denied and various other, it is submitted, irrelevant issues regarding the operation of the camera and the operating modules of earlier speed cameras and or radars. No evidence was given by the defendant, including there was no cross-examination or evidence as to the completion of a statutory declaration under Section 133 of the Land Transport Act. Relevant law. Law applicable to costs. 11. The defendant claimed costs in Criminal Cases Act 1967, the Costs Act. 12. Section 5 of the Cost Acts empowers the court, subsequent to any regulations under the Act, order some such sum as it thinks just and reasonable towards the costs of his defence. There is, however, no presumption as to costs, nor presumption for costs merely because of an acquittal, dismissal or withdrawal of charge. Section 5 states the following, and I'll put that in. Section 12 of the Costs Act holds that regulations may be made under the Costs Act prescribing the heads and maximum amounts of costs that may be ordered under the Act, including that were any maximum scale of costs prescribed by regulation. The court may nevertheless make an order for the payment of costs in excess of that scale if it is satisfied that, having regard to the special difficulty, complexity or importance of the case, the payment greater cost is desirable. 14. The Costs in Criminal Cases Amendment Regulations 2013, the Costs Regulations, prescribe the current scale costs under the Costs Act at Schedule 1, amending the Costs in Criminal Cases Amendment Regulations 1967. The title to the scale costs schedule is Fees Payable to Barristers and Solicitors in respect of the proceedings under Criminal Procedure Act 2011. The applicable scale costs for conducting a prosecution or defence in a case, including all matters and proceedings connected with or incidental to the case, for each half-day or part-day occupied in court, is a maximum fee of $226. 15. The cost regulations further state that the applicable scale costs where for any reason the charge is withdrawn or dismissed without a trial, where the defendant pleads guilty, for each half-day or part-day occupied in court is a maximum fee of $113. Costs of self-represented litigants. The defendant in this case is seeking costs as a self-represented litigant. Self-represented litigants are not generally entitled to any costs, whether in civil or criminal proceedings before the courts, save for disbursements. Unless they are themselves a practicing lawyer, the Court of Appeal in Merrick v. R. 2008, NZCA 45, a copy is attached marked A, confirmed the position as follows at 10. The general rule as to self-representing litigants. 10. The usual rule is that a successful self-represented litigant is entitled to recover disbursements but not costs. There is an exception to this rule in the case of a litigant who is a practicing lawyer. Such a litigant can be awarded both costs and disbursements. Both the rule and the exception are discussed in London Scottish Benefit Society versus Chorley 1884, 13 QBD 872 CA, Lindsay v National Bank of New Zealand Limited, number 2, 1935, New Zealand Law Review or NZLR 557 CA, and Brownie Wills v Shrimpton 1998 2 NZ Law Review 320 CA. 17. The Court of Appeal ultimately concluded that there was no jurisdiction under the Costs Act to make an award of costs in favour of the self-represented litigants. Conclusion, we'll skip the case law there. You guys can pause and read that stuff if you want to. Let's see, where are we? 18. Accordingly, it is submitted that in accordance with the dicta of court and the Court of Appeal dicta in Merrick v. R., the court has no jurisdiction to make award of costs in favour of the defendant. Principle relating to costs under the Costs Act. 19. In the event that the court considers that it is not bound by the Court of Appeal dicta in Merrick v. R., decision of the High Court recently of Sanders v. Police, 2017, New Zealand High Court 1838, attached hereto marked as B, His Honour Justice Gendall considered the issue of costs sought under the Costs Act following a successful appeal to the High Court against violent charges. The substantive appeal in that case had been allowed to by consent of the prosecution, and the conviction and sentence were squashed. The substantive issue related to the failure by the prosecution to disclose information which may have resulted in a more favourable verdict to the defendant. The defendant claimed inter alia that the police had not acted in good faith, that the defendant had made numerous disclosure requests and did not take proper steps to investigate all disclosure and had been made, and the appellant did nothing to contribute to that. The quantum was sought to the above scale cost maximum of $226 to the complexity and difficulty. 20. Justice Gendall considered the application of the Costs Act in that matter. He confirmed that the Act was a code and the ordering of costs discretionary. As unlike in civil cases, there is no overriding principle that costs should follow the event. And there's another section 13 there of Richardson P. observed in R.V. Leach and so on. And R.V. Rust in the court, so there's various case law that she's putting in here. 21. Justice Gendall further held that the factors discussed in Section 5 of the Costs Act were of some help in guiding the court's discretion at 15. I'll see her Section 15. He stated further, the court is considering Section 5 in the past and has indicated that the court should do what it thinks right in the particular case. It's up to the court's discretion. and there's further decisions there in case law. She's thrown a lot of case law in. 22. Justice Kendall stated further at 19 that the court which determines the appeal may make such order as to cost as it thinks fit, subject to a scale of costs which has been set out in the regulations established for this purpose. However, the court has the power to make an order for payment of costs in excess of that scale if it is satisfied that, having regard to special difficulty, complexity or importance of the case, the payment of greater costs is desirable. 23. In determining the application of law to the issue of costs in that case, Judge Kendall concluded that the issue of disclosure, which had resulted in the consequent appeal, and ultimately the police decided to not pursue a retrial, justified an award in that cost case. 24. As above, counsel submits that the court has no jurisdiction to award costs under the Costs Act in accordance with Merrick v. Police. However, in the event that the court did consider it had jurisdiction, under the principles of the Act and law as set out in Sanders v. Police, it is submitted that there are no good grounds nor special circumstances or matters of special importance in the circumstances of this case justifying an award of costs in favour of the defendant. It is submitted further that the disclosure issue in Sanders v. Police was highly distinguishable as to any facts claimed to exist in the present. The costs in this matter. 25. As above, it is submitted that the court has no jurisdiction to award costs. The defendant in the motion for costs seeks the following costs to be ordered as follows. A. A scale costs per the regulations for the appearance on 12th July, 7th November, 9th of February and 28th of February 2018, totaling $904. B. Research, study and preparing documents, 150 hours, totaling $2,250. And C. Travel costs, 4 times petrol charge per trip of totaling $80, and parking costs 4 times 24, totaling $100, which I meant to say 96. Total costs claimed $3,334. As per the cost regulations, schedule costs are claimable by barristers and solicitors for the scale costs of various steps and proceedings. The defendant at all times was self-represented in this matter and is accordingly not entitled to claim such costs. In the present case, almost all of the costs claimed by the defendant are costs not actually incurred as payable to a third party or barristers or solicitors as anticipated by the Costs Act. The only costs actually incurred by the defendant to a third party and claimed by the defendant are travel costs of an alleged $20 per day for petrol, though no proof has been provided, and parking costs of $24 per day claimed to have been paid to Wilson's car park, totaling $100, which is again meant to be 96. 28. Furthermore, the claim for the daily scales costs, in addition to the issue of the fact that they are not costs payable to barristers and solicitors, is that there is double accounting by the defendant, as he claims both scale costs and his alleged actual costs of researching, studying and preparing, which is generally costs which are covered by the scale costs in the cost applications. 29. The grounds relied upon by the defendant at paragraph 5 of the motion for costs dated 19th of February 2018 are stated as E. The prosecution had not acted in good faith to continue failure of due process of law. See 20 points listed with the motion for dismissal. Well, they didn't. F. The prosecution had failed to supply either initial or full disclosure to the defendant by their applicable dates mentioned above C1 and 2. They didn't. G. The charging document appears invalid due to no provisions being noted on the document. Agreed. H. The prosecution has failed after multiple attempts by the defendant to provide sufficient evidence to support the allegation against the defendant and failed to fairly and fully inform the defendant of the nature and cause of the action of the proceedings. Exactly right, they didn't. I. It is construed unreasonable and deemed improper to proceed any further by the defendant, as justice delayed is justice denied. It's one of their rules. 30. It is submitted that whilst the prosecution sought to withdraw the charge, which related in a dismissal by consent, this was only in reality by virtue of the fact that the failure by the Ministry of Justice to record the proceedings of the judge-alone trial, which was to necessitate a rehearing. The costs which would be incurred of such a rehearing for the public, given the nature of the charge, was not in the public interest. There was no concession, as is no concession, that this had anything to do with the sufficiency of the prosecution case. 31. Counsel submits that the defendant had received all material disclosure at the relevant times required under the Criminal Disclosure Act or shortly thereafter. The evidence of the witness, as set out in above section 9b, was that all relevant disclosure was sent to the defendant. As to the summary of facts, counsel understands this was provided soon after it was identified that such was not before the defendant, possibly because they didn't supply it, which is part of the initial disclosure. Numbnuts. Counsel understands that materially the only matters that the summary of facts included, which were not already provided to the defendant, were some legislative references relied upon by the prosecution. Well, if you're not going to supply the legislative reference, no offence is created, and therefore I'm not fully informed. Unreal. 32. The allegation as to the charging document being invalid is not accepted. It doesn't have to be accepted by you. The fact is it isn't. The notice of hearing appears to have been issued validly and in accordance with section 21(6), 7 and 8 of the Summary Proceedings Act. Any prejudice arising from any errors, if determined by the court, which she did, would be de minimis in any event and would not be invalidated under the provisions as to the accidental slip or errors in the Criminal Proceedings Act. 33. The prosecution does not accept that there were any failures to provide any evidence or particulars to fairly inform the defendant of the proceedings. In fact, the prosecution also provided the defendant clear direction towards the particular sections of the Land Transport Act which applied both prior to and at the onset of the judge-alone trial. And the court at the judge-alone trial facilitated the provisions of copies of the various sections of that Act. She's talking about section 133 of the LTA. Finally, it is submitted that the defendant has had the benefit of the infringement being dismissed by consent. Given the failure by the Ministry of Justice in recording the proceedings, as is submitted, that there is a real likelihood that he would have been found to have committed the infringement offence if the matter had been resolved by reserved decision following the evidence given at the judge-alone trial on the 9th of February. 35. The prosecution submit that the evidential sufficiency of the prosecution case was strong. That is based on the above facts and relevant law under the Land Transport Act, including, inter alia, that the defendant as registered owner of the vehicle was captured exceeding the applicable temporary speed limit by 14 km per hour by an operational and accurate camera operated by the witness. For avoidance of doubt, the material legislation relied upon to support the facts set out in 9 included substantively as follows. Law applicable to an infringement offence. 36. Rule 5.1, subsection 1 of the Road User Rule prescribes that the driver must not exceed speed limits, save in some limited circumstances where speeding is held not to be a breach under section 5.1.3, and which does not apply in this case. 5.1. Drivers must not exceed speed limits. 1. A driver must not drive a vehicle at a speed exceeding the applicable speed limit, being a permanent, variable, holiday, urban, rural, temporary, or other speed limit. 37. Section 40 of the Land Transport Act prescribes that a breach of such a rule, being rules subsequently made under legislation, is an offence. Offences related to rules, section 40, contravention of ordinary rules, subsection 1, a person commits an offence if the person contravenes a provision of an ordinary rule and the contravention of that provision is for the time being prescribed as an offence by regulation made under section 167. 2. If a person is convicted of an offence referred to under subsection 1, the person is liable to the applicable penalty set out in the regulations. 38. Section 133, subsection 1 of the Land Transport Act holds that the proceedings for moving vehicle offences may be taken under the person who was registered as the owner of a vehicle at the time of the alleged offence. Section 133, subsection 2 holds that in such proceedings the owner is presumed in absence of proof to the contrary, Section 133, subsection 4, providing it is an alleged that the owner was not entitled to possession or someone other than the registered owner was driving. Details must be provided immediately by way of a statutory declaration to the enforcement authority. Section 133 states in full as follows, and I'll post all that up for you guys to read. It's wholly bullshit. 39. As to the issue of the accuracy of the speed camera and its operation, which appears to be challenged at the judge alone trial, Section 145 of the Land Transport Act, as to the presumption of the accuracy applies as, and it's actually Section 146. See, Kate has failed to get so many things correct and factually accurate in this submission so far. It's unbelievable. But I chew the crap out of that in my response to it. And I'll post Section 146 up there, evidence of an approved surveillance equipment. It's basically saying their photo is evidence enough. It would be if it actually showed who the defendant was, or who the driver was. But apparently it just needs to show the car was there. 40. Accordingly, it is further submitted that the above law, coupled with the facts set out in the above 9, which is her recollection of what happened on the 9th of February, at lead at the judge alone trial, was such that the prosecution case was likely to have been successful, and therefore there is no success. Well, that sounds like presumptive. And therefore there is no success claimable by the defendant in any cost application in any event. Conclusion. 41. Accordingly, it is respectfully submitted that the court has no jurisdiction to award costs to the defendant, and even in the event that such jurisdiction did exist, sufficient grounds do not exist in the circumstances of this case for the court to exercise its discretion to do so. Dated at Auckland, this 23rd day of March, 2 days late from when it was supposed to be, at Auckland District Court. Counsel for the police. Okay, and after that she has supplied, let's see, 5 pages here of Michael Brian Merrick versus the Queen. The whole background, conclusion, appeals and case law behind it. She's supplied in the High Court of New Zealand Timaru Registry, my hometown, judgment of Justice Gendel. This is in regards to S.J. Shamey for the appellant and A.R. McRae for the respondent. And he appeared through audio-video link, did Mr. McRae, because he was in Christchurch. And this is that case law, CRI 2016-476-000007. Alright, and that's Justice Gendel's findings. All of these I will scan and I'll put them up with like 5 seconds each time, and you guys can pause and read if you wish. That, or Google search them, I'm sure you'll find them as well. But there's about 32 pages in this submission, and half of it is literally case law that she's supplied. Now, not being a lawyer, I don't understand case law, so it's really good of her to put all this in. And it just goes on and on and on, and that's the end of it there. Notice there's no signature of Justice Gendel there, and Simon, Shamey, Christchurch, and Dorman and Gruson and Co. in Timaru were the lawyers involved in that one. Next time I'm down in Timaru visiting my mum and dad, I'll have to stick my head in and say hi. Your case law was used to deny me my rights. And that's the end of the submission by the prosecution, or their memorandum as to why I shouldn't be paid costs. If you want to know exactly what I found in fault with this, it's all in my response to it. But just for a starter here, They did not supply me full disclosure. I was not even informed of the cause and nature before the judge had entered a deemed alone not guilty plea. He did all of that, just steamrolled over the top of me, was biased before I even stood in front of him. He had my camera stolen from me. He didn't read me out the charge. If he had done, he would have picked up what Nicola or Judge Mathers picked up 4 months later, was that there were no provisions. Without the provisions being on the charging document, no offence is created. The charging document is an invalid document according to the duty solicitor that I was told to talk to. I asked 4 separate occasions, 4 itemised documents that should have been supplied to me. She says right here that the defendant testified that he supplied me a photograph, whereas he didn't. He never ever supplied me a photo. That was supplied to me from the New Zealand Police Infringement Bureau right at the get-go. That's the only thing they sent me short of a notice of the infringement. So, you know, it's a whole heap of bullshit. She mentions my car, or the registration plate, being AAWU69. That's actually the site location of where EUR 591, the speed camera, was parked. My car's registration plate number is FAN394, nothing like it. She gets the dates completely wrong. She refers to the law that's incorrect. She insults the judge by telling them they don't have any jurisdiction to award costs, where clearly in the Costs Act states they do. And then rambles on about me being a self-represented litigant, where a litigant is a party to a civil matter, not a criminal one. I was in front of them as a defendant, and I was a self-represented defendant, and therefore I can claim costs as a successful, I know she doesn't like that word, but whether you like it or not, a successful defendant. They're saying because I wasn't a barrister or a solicitor, I'm not entitled to their fees. Disbursements, if I'd taken more record of the petrol that I'd spent on that day, kept receipts of petrol, or kept receipts of parking, or asked for receipts of parking, that could have been done. The judge said that as far as she's concerned, they didn't act in good faith, whereas I submit that they didn't act in not good faith because they failed to supply anything I kept asking them for. They just fucking ignored me because of their ignorant fucking attitude and not being used to someone actually challenging them over a speeding ticket. They fucked up in so many ways it's not funny. And her 32-page submission was answered with my 65-page response. Okay? And I've actually, because Kate saw fit to go through what she recalled and remembered on the 9th of February, which is, you know, when she was there for the judge alone trial. Mike was there in November, Vicky was there in July, so she could only recount what she was actually there for. Being that I was there for every fucking hearing, I did the exact same thing. And of course I have video and audio records to back everything I'm saying. And yet the judge still saw fit to say that she didn't believe the police acted in bad faith. Well, that's really an opinion. I have evidence to support that. Although the 4 emails and the proofs of service that I supplied seem to have gone missing from the complete case file. The exhibits, 6 exhibits that the police witness submitted on the day of the trial, seem to have gone missing out of the case file as well. And didn't they do a good job by, after saying and verifying in court, thus lying to me and the judge, the court taker was saying, yes, no, it's operating, he went down, he checked, he went back and verified it with the judge. Then they turn around and say, the button wasn't pressed. So someone's fucking lying. But let's not forget, they were all, you know, agents of the Crown, public servants in that registry, and therefore they're immune. So they can fuck up all day long and nobody gets in trouble. So they may consider themselves immune from a court of law or a court of record. Dare I say the word record, because you're not allowed to record in a court building, according to my mate Chris. But that's probably because they aren't courts of record. You know, otherwise they'd be recording things, eh? Otherwise you'd be allowed to keep record. They're courts of law. And law, to me, lay and weep. That's what law stands for, because honestly, after reading all of this shit and the amount of work I've done, This is all you can do, and by that I mean weep and laughter. You know, they don't seem to get that I don't give a shit about the money. To me, it's a matter of principle. Everybody complains about how broken the system is. Nobody gets off their fucking asses and does anything to try and fix it. They will sit there and moan about it, like whinging children to their parent. Whereas I'm of the firm belief that if you want something fixed, you'd better do something to fix it. Don't expect someone else to do something you're not prepared to do yourself. So, yeah, I will make sure that I've got to go and pick up my kids soon. So I'll make sure to sit down very shortly once I've got my children back from school and read you out my response. You'll take note of, she's using case law here. I'm using all the rules, legislations and facts behind in this one. But that's coming in part 32. Till then, guys, thanks very much for keeping an interest. If anybody wants to get a hold of me, channel name @gmail. Alright, it's not that fucking hard. I'm happy to respond to anybody. And, you know, of course, if there's trolls out there or government servants that don't like me and would like to voice their opinion, they're welcome to too. They'll go up on blast and then they'll be blocked. So, till then, catch you later, guys. I hope you had a wonderful day so far. It's 10 to 3. Catch you later.